So welcome everybody at the next Bytes of Innovation webinar. As you know, Bytes of Innovation is a deep dive into the future of medicine. And we do this together with renowned researchers, physicians, investors, and lawyers. And we do it every other week on Thursday. So we'll have one today and we'll have one in 2 weeks and so on. The concept is 15 minutes of presentation by our expert and then 10 minutes of Q&A moderated by Aline, who is our medical director, and by me. So participants, make sure to put your questions in the chat so that during the Q&A, Aline and I can moderate these questions. So today I'm proud to announce that we have Allison Bender here. And Allison is an attorney focusing on cybersecurity law and policy. She did her undergrad in foreign affairs at the University of Virginia. She received a JD from Washington and Lee University of Law and her LLM from Georgetown University. And Allison is still affiliated with Georgetown University as an adjunct professor. And she recently joined Dentons as a partner. Actually, she joined this week, I think, after last Monday, after she worked at Wilson Sonsini for about 3 years. Today, Allison will talk about navigating key legal issues in health data monetization. Allison, the floor is yours. Let me unshare my screen.
Sure. Thank you so much for having me. I'm really excited to be here and to speak with you all and kind of give a very high level overview of some of these key legal issues. Certainly we won't be able to address everything. You could teach a whole year-long course on these types of issues, but particularly for people who are thinking about it sort of at the beginning of their business strategy. And also as they prepare to essentially negotiate different types of contracts, I think this will be particularly helpful. So for today, we're going to focus primarily on US and California law. I will kind of mention other sources of law, including the GDPR, General Data Protection Regulation in the EU, but we're not going to address other jurisdictions in kind of any significant level of depth. And the first thing to consider when it comes to what your strategy is for data use and eventual monetization. First, what are the requirements that apply? And you'll see that there are both key sources and then key topic areas. In terms of where these requirements are, statutes and regulations, international, and then in the US, both federal and state laws and regulations. You're going to see them in your contracts from customers, from your vendors, business partners, potentially from your insurance company if you're seeking cybersecurity insurance, and also potentially from your investors. When I say contracts, I really do mean kind of broadly any legal agreement. This would also include non-disclosure agreements. It would include business associate agreements, as well as traditional sorts of master services agreement and licensing arrangements. There's also, in terms of sources of requirements, any individual authorization to receive HIPAA data, for example, protected health information, which we'll talk about in a little bit, may constrain your uses and subsequent disclosures of data. In the research context, informed consent as well can be a limitation on that. We'll look to the primary research purpose, any secondary research purposes authorized, and then also whether the scope is broad enough to permit subsequent additional uses. And then particularly for tort law or general consumer protection, you'll see the word reasonable a lot. You will think it is a lawyer's favorite word, and indeed it may well be. What is reasonable? Well, basically, it's what pretty much everyone else is doing. And how do you demonstrate that? Well, it's going to be by following well-established industry standards and frameworks, and also potential government guidance and policy statements, and doing what most of the people in the area are doing. If that's less than what is required by law, you're still on the hook for that. But if the law doesn't give a specific standard, industry practice is what you would look to decide what is reasonable in this area. And it's not just kind of one area of law. In terms of the sources of obligation, right? You find the statute, you find the regulation, you look in the contract, okay, what section is going to apply to the data use that I want to pursue. Very likely it's going to be multiple different areas. And some of this may depend on whether a regulation specifically applies, whether there's an exception, or whatever is specified in the contract. Generally, we will look to general consumer data laws and regulations. All 50 states and the District of Columbia, plus the 4 territories, have a data breach notification law now, and they are all different. Name plus birth date will trigger a notification obligation only in the state of Washington and North Dakota, unless you're a data broker, in which case you also have to notify in Vermont. They're all different. And so what you're required to protect and how you're required to protect it may differ. Similarly, a majority of states have information security laws, how you protect the information, what sort of policies and procedures you need to have in place by law. These all vary. Same with records retention and disposal laws, privacy rights legislation, which we'll talk about a little bit later, which is particularly important here as it relates to the sale of personal information, and then general consumer protection laws. There are also industry-specific laws for health and medical data, kind of using health data as a broad umbrella term to apply to not just patient records, but also research data that may be in the health context, digital health data, as well as general consumer wellness sort of data. Your Fitbit is not going to be the same as an EKG at the hospital by your doctor. And so knowing which area of the law you're in will help with that. At the federal level, of course, we have HIPAA, which is the primary statute we look to for patient privacy. And it's been amended a number of times, including by the HITECH Act and also the Cures Act. We also have the Substance Abuse Mental Health Services Act, which has been around for decades and really relates specifically to mental health and substance abuse records. The Common Rule, which is actually a regulation that applies to federally funded research involving human subjects. GINA, or the Genetic Information Non-Discrimination Act. The FTC Act, the Federal Trade Commission Act. And this is going to be particularly important if you're kind of outside of the HIPAA context. You have an app that involves health data. The FTC recently the commissioners voted to reinvigorate the health data breach notification rule, which does include substantial fines. And so it is on the agenda of regulators to really think about how to better protect this type of data. And of course, there are others that may apply depending on the type of data that you're interested in. There are also state laws that will apply. There are many state laws that are close to HIPAA, but HIPAA is a floor, it's not a ceiling. So if a state like California and the California Confidentiality of Medical Information Act, that can go above and beyond the standards that HIPAA would require. If you're aiming to comply with HIPAA, that is going to help you with most of the state requirements, but not all of them. And so having a good strategy, if you know that you're in that regulated space, will help you maintain compliance and reduce long-term risk. State laws can also impact your data use strategy if it's coming from an insurance provider. So there may be licensing requirements, such as in Texas or in California, that relate to how information must be protected by group health plans and other types of insurers. And there's also licensing requirements. For example, if you're thinking about working on an app or using data that relates to children, at the federal level, you'll think about the Children's Online Privacy Protection Act. But in the health context, knowing when you have consent, when you have valid consent from a minor, will be a state law issue. That also will relate to essentially when you can obtain consent to treat a minor for various types of medical services. If you're looking through the contract, you're also going to want to look at the intellectual property rights section. Are you getting enough rights to use the data? I like to refer to intellectual property law as essentially the Harry Potter wizardry school of law. If you miss the hereby in your incantation, you will not get a license to use the data. Instead, you'll just have a frog that no one can use. So it's incredibly important to think about, do I have the rights necessary to do what I want to do, including after the termination of this contract, and for the purposes that I want to be able to use it. You might have more permission from an intellectual property rights grant than you would under privacy law, but how those knit together will be important for your overall strategy. And then, of course, confidential information restrictions. If literally everything that you're getting from your customer, they have defined as confidential information down to even a business card, that's really going to constrain what you can do with the data over the long term. And so thinking about how these different puzzle pieces fit together will be really critical for your ultimate strategy. Other things to think about, just a few keywords that may look the same, but actually are slightly different. Particularly when we're thinking about health data and rights to be able to use it, the terminology really matters. So for example, personal information, personally identifiable information, and personal data may all seem like the same thing, but they actually relate to defined terms under law. For example, personal data in the EU under the General Data Protection Regulation, personally identifiable information, or PII, under the Privacy Act, which applies essentially to the US government's management of data, and then personal information, which we see in the California Consumer Privacy Act. Those are all kind of different terms that at a high level mean information that identifies or is capable of identifying an individual. There are some nuances and different interpretations by regulators, but if you could use the data to identify a human being, you might have a privacy consideration. And that becomes even more important when we think about it in the regulated context of HIPAA for protected health information. So individually identifiable health information relating to an individual's current or future medical condition that is essentially collected or received by a covered entity, which is a healthcare provider, a group health plan, a healthcare clearinghouse, or their business associate, or their sub-business associate for a healthcare treatment or operations purpose while performing a covered function. So lots of nested definitions in that, and we'll get into that, but they're not the same thing. And that's important when you get to your contract strategy. Similarly, research data is not the same thing as PHI. Not all data is, or not all research is conducted in the context of a covered entity providing healthcare services. And so it may not be PHI, even if it's collected at a hospital. And so understanding the nuances there will also increase your flexibility, potentially with the rights and data that you do obtain. The last three are kind of concepts that all go together, but you can see there's even kind of a debate in the different statutes about whether we should hyphenate de-identified or not. HIPAA uses the hyphen, the CCPA does not. And how the US looks at it is very different than how our colleagues across the Atlantic would. If you're European, you're going to use your S in anonymized and pseudonymized, but de-identified and anonymized are not the same things if you're looking at it from those two different perspectives. Anonymized is essentially like not possible to identify a person. Pseudonymized means that it's capable of potentially identifying a person, but it's been masked or coded in such a way, or it would require a combination with other data to actually result in the identification. With de-identified, whether HIPAA or CCPA, there's a much clearer standard. And we'll talk about that in the upcoming slides, but statistically a very small possibility that using current means you could re-identify an individual from the data that is available in the data set. So all keywords, and they all have nuances that are important to think about as you're reading through contracts or considering what your strategy will be. And really begin with the end in mind is critically important. Most startups are commonly focusing on providing services to covered entities or working directly with consumers to empower them to do more with their data, whether that's their personal health record or general wellness data, or allowing them to better interact with their healthcare provider, or maybe have better billing from insurance, all sorts of things. But this is very much kind of focused on that view. And if you are thinking about your long-term business strategy, what do you want to be able to do with the data? Do you need to be able to sell it? Do you need to be able to monetize it? Do you need to be able to identify people by name in an FDA application? Do you just want it for internal development purposes? Do you need to make sure that you can assign or transfer your assets without notification to every single customer? And certainly without their consent, that you're going to want to think through what is your business plan? How does data and data use fit into that long-term strategy? And then make sure that when you're negotiating the contracts, that at least you have enough rights to perform the services. You certainly wouldn't want to violate the contract or violate law by not having enough rights in the data or consents for use to even be able to perform services. And then thinking through also what are some of the common secondary purposes that you would want to negotiate for in your contracts. If you are covered by HIPAA, data aggregation services and the right to de-identify are optional. If you want them and if you think you need them, you actually have to negotiate for them. And even then, you may find that your right to de-identify is constrained by the contractual language. If you de-identify data under HIPAA, if you de-identify PHI, I should say, the resulting data is no longer subject to HIPAA. So you can do with it kind of what you want, with a little asterisk that we'll talk about towards the end of the slide deck here. But it gives you a lot more freedom in terms of what you want to be able to do. You may find that your customer, the other party that you're working with, still wants to constrain that, doesn't want you to be able to retain the data, maybe will limit your uses even of the de-identified data. So those are all things to think about. Marketing and sale too are going to be very hot topics. HIPAA would require additional authorization from the individual if you were to use PHI to market services to them, or if you were selling their data. So that is going to be a reach in most contract negotiations if you want to be able to do that in identifiable form. You may have more flexibility with de-identified data. There are going to be quite a bit of nuances depending on your jurisdiction and other laws and requirements that may apply. But begin with the end in mind, think about the contract period, and think about what comes after. The next few slides, I hope, will be very practical takeaways. They're a little bit dense in terms of wording, but these are some of the key issues I think that businesses are likely to encounter in this space. One is whether HIPAA even applies at all. It is very convenient for a covered entity to say, just sign this business associate agreement, which is of course going to be very restrictive and very conservative. And then we'll do business with you. You may not even be a business associate. And there is a complex analysis that goes with whether you are acting as a business associate, whether they are acting as a covered entity, and then also whether the services are being performed for a healthcare treatment, payment, or operations purpose, and also whether insurance is being checked in some way, if there's reimbursement being sought, what is the eligibility. These may be triggers for whether HIPAA applies. Generally, private pay is not going to trigger HIPAA. State law will still apply, but not HIPAA. You can also still receive data from a covered entity if they have obtained the individual's authorization for disclosure and your subsequent use of that data. So you don't need a BAA if you have an individual authorization. And so if you receive data subject to the authorization, it's not subject to HIPAA. So things to think about there. Again, making sure that if you need it, you get rights to data aggregation services, rights to de-identify, and then, if it's de-identified, is that still meaningful to you? If you're going to get de-identified data about a medical device and the date of service is important to what your long-term plan is, you can't have dates of service under the safe harbor method. So is it going to be enough? And then can you commit to not re-identifying the data? In the research context, same sort of applicability rules. The common rule for human subjects applies to federally funded research, and really an institution that receives federal funding of any kind, it's enough of a hook for the common rule to apply. If it's fully private, the common rule does not apply. This provides certain rights to individuals who participate in research studies to have notice and consent, and even where notice is not given, that there is supervision, usually through an institutional review board, that addresses the ethics of that research. And the de-identification standard that's in the common rule differs from HIPAA and differs from the CCPA a little bit. But with research data, is the scope of the informed consent sufficient for the data uses that are intended? Are secondary uses of the research authorized? Do you need supplemental notice or consent for additional uses? And if so, is that a commercially reasonable undertaking? Going back to get consent from 10,000 data subjects is almost never done because it's very expensive. So those are things to think about. And then also, if you're getting the data with accompanying medical records or with biospecimens, does the data use still match your strategy? If you're working on new algorithms to figure out identification of rare diseases or beneficial microbes that could be used for commercial purposes, if one of the requirements of the research study is that the biospecimens have to be deposited into a publicly available repository, are you still going to be able to protect your trade secrets? So things to think about there. And you've got to read the documents. I know we're coming up on time here, but just one last slide to do a little bit of a deeper dive on maximizing your data use rights and contract negotiations related to health data is considering the CCPA. So the California Consumer Privacy Act, or the CCPA, went into effect January 1 of this year. Originally, there was a lot of confusion and uncertainty about what CCPA de-identified, no hyphen, meant in the context of HIPAA de-identified with the hyphen, and how those two played together. And another law was passed to amend the CCPA. This is AB 713. And it does clarify that PHI de-identified under HIPAA is considered de-identified under the CCPA, but a number of additional requirements apply to utilization of that exception. Specifically, you have to disclose whether you sell or disclose personal information de-identified pursuant to HIPAA as it relates to California residents. And you also have to say whether you used safe harbor or the expert method for the de-identification process. Additionally, de-identified data later re-identified under the CCPA, basically all the old laws apply. It's not the case under just straight HIPAA. For example, a covered entity that provides data under the safe harbor method, as long as they have no actual knowledge of the likelihood of re-identification, that's sufficient. They're not required to engage in ongoing monitoring. And if someone else, 3 vendors down the line does re-identify the data, they would not become subject to HIPAA because of the re-identification. That's different under AB 713. We're still looking to California to provide additional information on how they plan to implement this. And currently, we don't have enforcement history because it is very recent, but you are likely to see in contracts for de-identified data, new contract language that bars re-identification subject to certain purpose-oriented uses that are quite similar to HIPAA, and the requirement to flow down these obligations on any further recipients of the data. And also, I would say that it's expanded the scope of who's subject to this obligation. The CCPA includes exceptions for nonprofits. It also includes thresholds. So like if you make more than 25 million in annual revenue, you're definitely subject to the CCPA. There are others that apply, but here, those thresholds are no longer present with this particular exception. Basically, if you do business in the state or if you reside in the state, this requirement would apply to you. So lots to think about, I think, but basically begin with the end in mind. And as you're going through things, how does this affect my long-term goal? Do I have enough rights and data to be able to do what I want to do? And do I have enough leverage with this particular party to negotiate for more? So that's a quick highlight reel of considerations and data use. I would be really delighted to take any questions that you all may have.
Thank you, Allison. It was a great presentation of some questions. So I'll first make the question myself. Is there a difference between selling data and licensing data from the point of view of the covered entities?
So from the point of view of the covered entities, under the CCPA, no. The definition of sale is so broad. It would include selling, renting, licensing, transferring, basically doing any sort of sharing or disclosure in exchange for a thing of value. Very, very broad definition of sale there. With the HIPAA definition of sale, it will be more narrow, but I think that you'll find that most covered entities take a very conservative posture, and likely in most cases would still seek authorization for something that looks like a sale.
Great. Okay, thank you. And then we have another question from Michelle. She's asking, how is data re-identified?
So there are all sorts of I think really fun to read studies about what pieces of data you can pull together. I'm forgetting the name of the researcher at Harvard that has done quite a bit of this, but you should definitely look them up. In one example, they took de-identified data from a study, combined it with other data, and was able to point out when the governor of Massachusetts had the flu. It depends on what's in your data set. It depends on the other sources of data that are being commingled in order to re-identify that individual. But this is one of the primary criticisms of the Europeans of the US system is de-identified. They don't think really means de-identified. It's a little too easy with enough data to figure out who people are.
Nice. So I have one additional question. You mentioned it briefly in the beginning, but maybe I missed it during the presentation. But the differences between the US HIPAA and European GDPR in terms of policies and regulations, like what are the main like key differences there?
Sure, sure. So the General Data Protection Regulation, or GDPR, in the EU applies to basically all personal data. There are additional requirements that apply to medical information at the member state level. So still kind of a two-tiered system there. With the GDPR, a lot of the focus in terms of compliance will be on ensuring adequate consent or another lawful basis for processing, documenting your policies and procedures, your record of processing, mapping your data, and considering the data flows. HIPAA does not have a cross-border transfer restriction. Very often, entities that do work for the Center for Medicaid Services, CMS, will apply one because of guidance that relates to an audit requirement, but it's not actually required by HIPAA. You could still process PHI in Canada or Jamaica or France or whatever. That would be fine with HHS, OCR. With the GDPR, you can only transfer data internationally if the country has been deemed adequate in the view of the EU, or if you have implemented one of the permitted mechanisms for transfer, which really at this point are just the standard contractual clauses, in particular the new ones that were released September 28th with additional supplemental security measures. So if you are doing anything that has to do with European personal data, you will see a data protection addendum that very likely includes the standard contractual clauses.
Nice, thanks for elaborating on that. So we're running a little bit over time, so I think we should close it out. Thank you for a very interesting presentation. This was very helpful, and we see that your information is there for anybody who has questions after this. I assume, Allison, it's okay that they reach out to you?
Of course, I'd be happy to answer any questions anyone may have.
Perfect. Thank you for that. And then I would like to say that in 2 weeks, we will have Iman Banerjee, who is a professor at the Mayo Clinic, and she is going to talk about analysis and integration of unstructured medical data. So thanks everybody for attending, and I hope to see you in 2 weeks. And thanks, Allison, for a great presentation.
Thanks for having me.